All right, good afternoon, ladies and gentlemen. It's exactly 5 o'clock, so we'll make a start. Thank you very much for joining us. We appreciate you following our training webinar series. My name is Andrew Schaefer from Trafalgar. I'll be your host and facilitator this evening. Before I introduce our guests and our panelists tonight, just a few housekeeping comments. First off, this is our last training webinar for the year. We'll conclude our 2024 series with this webinar. We'll then go into a year-end recess and we'll commence again in March next year with another round of training videos. A reminder that all of our training content is freely available on our training website, which is training.trafalgar.coza. And between 3 years of training webinars such as these, plus questions of the week, which Karine very capably puts together, they're all online, you should be able to find very good comments, very good content regarding most frequently asked questions, most common issues that occur in community schemes. We also have all the legislation in searchable Word format in our training on our training website. So it's a really good place to go. There's absolutely no cost. It's very comprehensive, and you should be able to get a good start to investigate or address any particular issues that you might be confronting in your community scheme. We'll endeavor to complete promptly by 6 p.m. this evening, as we usually do. And please post any questions you have in the Q&A, not in the chat, but in the Q&A, please. We will automatically send a recording link for this webinar. So we are recording it with permission. So we'll send you the link to the recording, which will be posted on YouTube and our training website, as well as the slides to all participants. So you don't need to put an email address in the Q&A, and by all means delete if you're not interested, but most people do ask us for the recording link as well as the slides. We did receive many questions emailed to us before tonight. I will just say we won't have the time and opportunity to go into particular disputes and the merits of particular disputes. That's not really the point of this topic. What we are hoping to do is to, raise the topic of the role of CSOS, the objectives of CSOS, some of the new legislation which CSOS is involved with, and we're very pleased and privileged tonight to invite some special guests from CSOS who will be talking to us, on CSOS, its role in the sector, and, the work they're doing behind the scenes to expand their scope and impact. So I'd like to start by introducing Lindiwe Bulo, who is our first special guest from CSOS, just briefly by invitation, and welcome, Lindiwe. Lindiwe is an admitted attorney of the High Court with more than 25 years of experience, specializing in property law, governance, and alternative dispute resolution. Lindiwe has held several executive and senior positions at institutions such as the PPRA, the National Health Laboratory Service, Broadband Infraco, and others. Since 2019, Lindiwe has been an adjudicator at CSOS. So welcome, Lindiwe. Thank you very much for joining us this evening.
Thank you for inviting me.
Also joining us is Chapiso Tipe, also from CSOS. Chapiso is the CSOS Senior Manager at the Office of the Chief Ombudsman. Prior to joining CSOS, she was a director at the National Treasury, responsible for managing the Public Financial Management Capacity Development Program. She's got over 10 years of senior manager experience. Chapiso has special interests in strategic planning and monitoring, corporate governance, and project management. And we welcome you tonight, Chapiso. Thanks very much indeed for your time. Also joining us from CSOS is Ryan van der Westhuizen, who will talk to us later in the agenda. So to kick off, Lindiwe, can I hand over to you? And if we could just kick off with the CSOS dispute resolution process, and if we can let you cover that topic and any questions that arise, I can perhaps pose that to you at the end. And sorry, just to quickly introduce Karine Coetzee, who's our stalwart national property or national community scheme manager, facilitator of these events, and will assist me with answering questions. And our contact details will be given at the end. So any questions that arise that we don't touch on or don't answer to your satisfaction, by all means, please reach out to us by email Our details are there. We'll endeavor to get back to you tomorrow, and we are available at any time if questions arise ahead as well. And then Peter Menon, my colleague, head of marketing and legal at Trafalgar, a director of Trafalgar. Welcome, Peter. Thanks very much for joining us tonight. Lindiwe, over to you. Thank you very much.
Okay. Thank you. And good evening, everybody. Yes, yeah, my name is Lindy Webulo. I'll be talking to you about the topic that I really like, which is something that I do as part of my life, adjudications, regulatory ambit as the CSOS, right? Firstly, we do what we do because of Section 4 of the CSOS Act, which is to regulate community schemes. And how do we do that? By conducting dispute resolutions and make sure that the dispute resolution is effective, is cost-effective, and efficient. We strive towards that. We have a responsibility to provide training to community schemes, to the trustees, to the board of directors in the case of an HOA, to managing agents, like Trafalgar and everybody else, to occupiers. For us, occupiers will be a person who occupies your property, does not have to be the owner. We provide training to those and everybody else who wants to know about what we do and to promote good governance and to ensure that the schemes are properly governed, the quality assurance of their conduct rules and management rules, which is something that Ryan will talk about at a later stage, because currently we quality assure management rules and conduct rules as set out in the, not just the CSOS Act, but the Sectional Title Schemes Management Act. Thanks, Karen. So the prescripts in terms of dispute resolution, what do we do, right? Or what governs us? It's the CSOS Act and its regulations, the Sectional Title Schemes Management Act and the regulations there too, the standard operating procedures, which tells us how are we, when we receive a complaint, how long does it take for us to finalize the dispute and the entire value chain, the process there too. And then the practice directives. As you know, Section 36 gives the Chief Ombudsman an opportunity to form practice directives on. So we have a practice directive on dispute resolution. The 2019 one, which was amended several times and is going through another amendment, and the conduct rules, the code of conduct for adjudicators as well as conciliators and everybody else who works at the CSOS, to make sure that when we do what we do when we conduct adjudications, we must not be biased, we must be fair, and try and give both parties an opportunity to be heard. So that's basically what governs the process. These pieces of legislation, the practice directive, the SOPs, and the code of conduct for adjudicators and conciliators in this case. Thank you, Karen. Next one. Yeah, so when you lodge a dispute, the application is in terms of Section 38, right? You must make sure that it falls within the ambit of the CSOS Act, and especially Section 39, right? Who can bring a dispute to CSOS is any person who has a material interest in the community scheme. So you must be, it's either you are a member of the community scheme, you are an occupier, you are a managing agent. Remember, managing agent bringing up a dispute on behalf of the scheme itself, on behalf of the trustees, right? An owner and a bondholder. So if you have a material interest, then you can bring a dispute. But then if you no longer have a material interest in the scheme, you cannot bring a dispute at the CSOS. So the next slide. Yes, said this, affected persons can be an association. An association is a community scheme itself. So it can be a body corporate, an HOA, a share block, and the others, right? You can be a member of the community scheme. Occupiers, so your tenant can bring a dispute, but the owner must know that you're bringing a dispute. The tenant can bring a dispute, right? If the matter is about a community scheme administration in a community scheme. Let me just clarify that. Not everybody can just bring it, right? And developers, we know that they are regulated by the National Home Builders Registration Council, yes, the NHPRC. But then if a developer is still a member of that scheme, can bring a dispute, and others bring a dispute because they are in partnership, you are, a trust as well. If the owner is a trust of a community, in a community scheme, they can bring up a corporation. You find that the property is registered in the name of a company, so the directors or a representative can bring a dispute in a community scheme. They have private and public entities. There are schemes that fall within the CSOS ambit, but they're also regulated by, for instance, SHRA, South African Housing Regulatory Authority, Social Housing Regulatory Authority can also bring a dispute, or any representative. An attorney can bring a dispute, a managing agent, we've already said that, can bring a dispute. But then in the case of an attorney bringing a dispute on behalf of a scheme, there must be a resolution and they must apply, right, in terms of Section 52, to be represented by an attorney, so the adjudicator can decide that, yes, a legal representation is necessary or not necessary. Thank you. You can go to the next slide. The types of disputes that you can bring to the CSOS, right? You look at the prayers for relief. It's financial issues. So if it's Trafalgar, you have a lot of matters, where people are not paying their levies. So those matters can be brought. It's financial issues. And in some instances, if the issues are about insurance, apologies for that. If the issues are about insurance, can bring such issues, or you are unhappy with the manner in which your levies are being calculated, you bring that dispute in Section 39(1)(c). And then your area levy matters, usually it's 39(1)(e), so you can bring those. Behavioral issues, the parking, the parking issues, those are behavioral issues that you can bring to the CSOS in terms of 39(2). And then governance issues, where the conduct rules or the management rules of the scheme are unfair, right? Unconstitutional. So those rules, we do have a practice directive on undesirable rules. So if the rules, you feel that though the rules were approved by the CSOS, but then you realize when the rules are being applied that, no, this can't be right? Or in instances where the rules said no pets allowed, right? And then you've amended the rules, then you must come back to CSOS, right? For the amendment of those rules. Or if people are not adhering to the rules, those are the disputes that you can bring in terms of Section 39(3) of the CSOS Act. And then in terms of meetings, again, those are the disputes you can bring. A meeting was not properly convened, or the resolution of the meeting did not consider the interest of the scheme. So you can bring those issues. I'll emphasize the fifth one, right? It's 39.5. 39.5, there's only A and B. It's about managing agents. So you cannot just bring everything against managing agents because they are regulated by the Property Practitioners Regulatory Authority. Right. So here, under 39.5, the only thing that you can bring against the managing agent is contractual issues. So if you're saying the managing agent is not adhering to the contract that they signed, so you ask for a declaratory order, or you're asking that the managing agent's contract has been terminated and the managing agent is refusing to leave, or it was not properly terminated. So it's those two issues, not everything else, because they do have their own regulatory body. Okay. And then private and common areas, your leaking roof, your repairs, and all of those things. Those are the things that you can bring to the CSOS. And then the seventh one, 39.7, there's an A and a B. The A is access to information. So you are saying, I'm not giving you, asked for the minutes of the AGM, the managing agent or the trustees are not giving us, or the board of trusts or of directors are not giving us access. So you can bring that in terms of section 39.7A. Then we go to the next slide. The B, it's about urgent matters. Right. So the process when lodging a dispute, we have a prescribed form. We have a prescribed form that you can complete. It's either you bring it to the regional offices, or we have the satellite offices now. You can bring a dispute there, hand deliver it, or by email, or you can post it. Mostly, majority are emails. We receive emails, right? Then the dispute will be registered. And then a reference number will be allocated. It's a unique reference number. You cannot share a reference number. It will be a unique reference number. It will be allocated. And then our case management officers will go through your application to check if you have exhausted internal remedies. It's one of the issues that the parties' details are correct, the matter falls within the CSOS Act, or if it's not clear, we've also prepared a checklist. You go through the checklist to see if this matter actually falls within the ambit of the CSOS. Right. So they'll then, if there is further information, they'll write to you, please give us this information. And if it falls outside, then the matter will be rejected. It's accepted, it falls within under one of the section 39 matters that I've already mentioned. Then the CMO, that's a case management officer, the CMO will then send out a notice in section 43. The notice will be accompanied by, meaning annexed to the notice will be that application, your application, together with annexures. The respondent will be given 7 days. Please respond, Mr. So-and-so, Mr. So or Mrs. So-and-so, or the trustees, please respond within 7 days. Right. And then they respond. That response will then be given to the applicant. The respondent have submitted within the, or they've asked for an extension has been granted, right? So please respond. Then they'll send you a section 44, giving the applicant an opportunity to comment. Right. Now, the applicant will then be given 5 days. Based on the response, the applicant can decide, you know what, actually, they've given me the explanation and I'm satisfied, I'm not proceeding, the file will be closed, or the file will then proceed to conciliation, or if there was no response, it goes directly to adjudication. Then the conciliation will be that section 47, right? And then if the matter is not resolved, then it goes to adjudication, referred to adjudication. Thank you. Then we have those urgent matters, the 39.7b. Not everything is urgent. We'd like to keep it like that. Everything would be urgent and then issues 48 hours. If possible, that'd be great. Right. That can be brought on an urgent basis. And those are health-related issues, right? That can be brought on an urgent basis. And if maybe safety is at risk, or there's been a disconnection of electricity or water, or denial of access, those are the urgent matters that you can bring. But remember, disconnection of electricity without a court order. Without a court order. Where there's a court order, tough is. But where there is no court order, then you can bring those matters on an urgent basis. So we try and resolve those matters within 48 hours at most. We try. So where a person has been denied access, that's why those matters we even adjudicate in the middle of the night, because if person does not have access, or even the kids are outside, cannot access their home, those are the matters that we prioritize and deal with on an urgent basis. And we use the practice directive to do that. Thank you. Slide. Yes, a file then is allocated. Remember, I spoke about conciliations. Either it goes directly to adjudication, but for the urgent matters, it does not go to conciliation. It goes directly to adjudication. Matter is not urgent, it goes to conciliation, right? So it must be allocated to a conciliator within 15 days. Conciliator must deal with this matter within 15 days. So I'm even trying to address the timelines, right? But we're not considering the backlog currently. But I'm just saying the normal timelines in terms of the SOPs. It's our standard operating procedures, right? Given 15 days. So the matter must be set down within that 15 days. The conciliators are legally qualified. Some of them were mediators previously, so in their past life. So they know they must not be biased. They just facilitate the process. So the parties must try and resolve the matter amongst themselves. A conciliator will not resolve your issue. The parties must be willing to reconcile, right? Which is the best way, to be honest, because then you take control of the process as opposed to giving it to an adjudicator to decide your fate. Then, if the dispute is settled, great, and settlement agreement will be drafted. And in that settlement agreement, we normally say, if in default, meaning should one of the parties be in breach of the settlement agreement, that a settlement agreement will be made an adjudication order. But not all of them. In most instances, there are those, and when it's not settled or in breach, they say the matter will be referred to adjudication. Thank you. So if the matter is not resolved, then that section 48 will be issued, and then a non-resolution certificate, a certificate of non-resolution will then be issued to the parties. The matter then is referred to adjudication. Okay, so the adjudication process, the file is allocated to an adjudicator, right? We use a system called, we use SharePoint, right? A file, we get a link, right? So when an adjudicator receives the file, we'll then look at it. If there's a need to conduct an investigation, like an area levy matter, just a simple area levy, not simple, some of them are very complex, to be honest. An area levy matter, you look at the date that the last statement that you received was in January, right? And now we are in October. So then using that investigative powers, then address an email to the parties that please inform me whether the matter has been resolved. If not resolved, the matter will then the managing agent in most cases, or the trustee, or whoever has brought the application, will then requested to give us the latest levy statement, so that then it's current, and in some instances the matter has been resolved and then will then be closed. So we have final written submissions that will be sent to the parties, and then based on that, decide whether the matter will be decided on the papers or you'll have a face-to-face adjudication. A lot of people, because of COVID, now it's more convenient to continue on the papers. So a lot of matters are decided on the papers submitted by the parties. Then an adjudication order will be drafted, and then it's sent to quality assurance. It's a quality assurance adjudicator. They look at the English, and if there are any errors, or if there is any matters that they would like the adjudicator to consider. There are instances where they'll say, have you looked at your have you exercised your investigative powers? In that case, then you go back. They have 7 days to quality assure the order. So when someone says, how far is my order? No, the order has been drafted, it's with quality assurance, it's 7 days. Once it has been received from quality assurance, then you have 3 days as an adjudicator, right? To send out to publish that adjudication order. You send it out to the parties, right? So if the party has not complied with that adjudication order, you then can apply for an enforcement order, right? An enforcement order, it can be exercised, meaning the matter can be taken to the High Court or to the regional court that has jurisdiction. If it's for specific performance, right, the matter will then go to the High Court. Or if the limit is above the jurisdiction, even if it's an area levy, but it's above the jurisdiction of the magistrate's court, it will then be enforced in the High Court. And then most of the matters fall within the jurisdiction of the magistrate's court, because it's within the magistrate's court jurisdiction. So once that has been done, you've applied for an enforcement, right? The sheriff will then serve it. The CSOS is no longer involved in that process. But then the benefits, I'm actually been answering some of the questions that I saw. The benefit of doing that is that you don't have to go through and issue summonses, because it has the same force and effect as if it was of that court. So if it's a High Court matter, it will have the same force and effect as if it was from the judge of the High Court or the magistrate in the case of a regional court magistrate. Okay, that has jurisdiction. Thank you. You are unhappy, an adjudication order has been issued, and you are unhappy with that adjudication order, right? You have 30 days to appeal, to lodge an appeal on a question of law. So you do not appeal just everything. So if you feel that the adjudicator has erred in applying the law, that's when you can then appeal against that matter, adjudicator, right? You appeal, and let me emphasize, because the adjudicators, have the same immune, just like your judges, right? So you cannot then, when you're appealing, because an adjudicator, or in your opinion, the adjudicator has erred, you want a cost order against an adjudicator, right? Unless there was malice, or there is something that you felt that maybe the adjudicator acted in and I don't know, because there aren't any instances where the appeal is against an adjudicator as a person. So you then take that to the High Court. That is your section 57. So the enforcement, it's section 56. 1 and 2. High Court is 2, and Match Court is 1. So it will be stamped by the clerk of the court in the case of a regional court, or it will go to the High Court, the registrar of the High Court in the case of a High Court matter. So the appeal process is then you appeal in the court that has jurisdiction, and in most cases we abide by, in most cases, not in all instances, looking at, you always look at the merits. So if there is a need, if we feel that this has an effect that it might affect the jurisdiction of the CSOS or the regulatory powers of the CSOS will then usually then file a notice to oppose or will be a party to that process. But in most cases, because the intention is to ensure we have a regulatory system that works, is to file a notice of intention to abide. It's a notice to abide by the decision of that court. So whatever the court decides, we will, or in most cases, in most of the cases that are referred back to the CSOS, is that the courts are saying, maybe you did not look at this, go and decide on this. We feel that CSOS, you are better placed. So in most cases, these appeal matters are referred back to the CSOS to be heard again by the same adjudicator or by another adjudicator. Thank you. Okay, let's go to the regulations of community schemes. Remember, I said Section 4 tells us exactly what you must do, right? We must regulate, monitor, and control the quality of sectional title governance documentation. Those documents are your conduct rules that we must make sure that they are quality assured, and the management rules. So ensure a good, proper governance of community schemes. Remember that section 39, 3, when I said there are instances when you feel that the rule was not properly applied, right? So it speaks to this one as well, the promotion of good governance of community scheme. So, and conduct training. Training not just for members of the community schemes, but for us as adjudicators and conciliators and everybody who are involved in the process. So we conduct these trainings to make sure that the CSOS achieve its objectives as set out in its mandate. We can go to the next one. Thank you. Okay. That's it.
Lindiwe, could I come in with 2 or 3 questions before we go to the topic of transformation? A lot of interest and questions from our audience tonight on the backlog of CSOS matters and disputes. You know, you can maybe just talk to recruiting, extra adjudicator capacity, you know, the system improvements you're working on with CSOS Connect, and maybe just sort of an indication of when you think the capacity will be in place to bring the timelines down to the 90-day turnarounds that are supposed to be the turnaround times for CSOS disputes. So if you wouldn't mind just talking to that, please.
Sure, with pleasure, Andrew, sorry. Yes, we're working on it. We are working on that tirelessly. We've appointed, actually, I can report that we've appointed additional part-time adjudicators. We are in the process. We are busy with the procurement processes. Now the matter is at bid evaluation committee, which is a committee that evaluates to ensure that they've complied, they meet the criteria as set out in the term of reference. So the process is underway. About 18 part-time adjudicators have been appointed and have already started. Right. So we now want an additional to supplement that 18. Obviously, 18 is not sufficient. So we looking at that should be finalized in the next month or two, because it's at adjudication, at evaluation currently, right? That matter, then that will help in reducing the timelines. And we've also, what we've done with these timelines, we've set it up in such a way that there are the more urgent matters. As I've said, we're not compromising on urgent matters. We're still giving that priority, right? So, and dealing with the backlog. So we've decided that as the management has decided, then we use the FIFO, first in, first out, to try and deal with the backlog. So currently, if the matter is sitting with Lindy or with whoever, any other adjudicator, we can tell you that your matter is number, just like in like SARS or any other institution, they'll tell you your number 15 on the line or your number so and so, but at least it gives you a bit of comfort. It's not the best way, but it gives you sort of comfort that the matter, at least it's being attended to. The backlog now, it has been reduced to a certain extent, right? I know this is not the best, right? But what we have decided now as an organization is to give it a priority, to make sure that the appointment, drop everything, the appointment of additional adjudicators has been given priority to address. And I would like to apologize to our stakeholders on behalf of CSOS for the backlog. So the matter is really being attended to. And with CSOS Connect, because with the automating of the system now, right, at least that it creates at least some independence. At least the schemes are able to do it themselves. So at least with the registration processes. But then for the adjudication part, they are currently busy in that final stages. The SFS, it's the whole IT stories. It's been done, for adjudications. So that will be finalized.
Okay.
So and the backlog, we're expecting that it shouldn't, in the next 3 months, there should be an improvement.
Okay, thank you. And a last quick question before we go to the transformation efforts of CSOS. A good question is, in terms of enforcement of CSOS registrations and the payment of CSOS levies, why does CSOS not just go to the register of sectional schemes, and you can also trace all the homeowners associations registered and cross-reference who is registered, and then be able to target who's not registered, with the physical addresses are available as well. So is that something on the radar? Is there going to be an enforcement process like that? At the moment, it seems to be more advertising and, communicating than full enforcement.
Oh, I'm glad you raised that. That's a good question. We have contacted the deeds office, right, to get all the scheme universe, right? We're busy with the validation and verification of the existing. So with the deeds office, right, the issue is the homeowners associations, right? Because remember, it's not a sectional title, right? So we are in that process, and what you've raised is a good one. So the enforcement part, the reason why we are on this drive is when you cannot enforce something that you yourself did not do. So we must get our regulatory processes correct, so that when we come with the enforcement part, at least we know we have the scheme universe, right? Which is, we are actually in that process. I thought maybe you had spoken to someone at the CSOS who told you we are, that's what you're currently doing. Okay. We are in contact with the registrars, of the deeds office. Thank you.
Thank you so much, Lindiwe. Very good. So we're going to go over to Chapiso now. Thank you, Chapiso. And if we could touch on the topic of the transformation efforts in that CSOS is driving. Thank you.
Most certainly. Thank you so much, Andrew. Thank you, Lindy. Maybe just to give a quick context to what resulted in us having to do transformation. And I think we can all attest to the fact that it's a government agenda, which we all are required to drive. So we have a transformation program, and within that program, we've got two themes that we are trying to achieve, or rather to implement, that relates to capacitation and access to funding. And the second one is to look at market access and opportunities, because when we did our research from our side, when we finalized our concept note, we found that there are certain gaps that needed to be addressed. Now, maybe also to indicate that when we submitted the concept note to the minister, we had proposed that we should have a startup capital to at least fund our emerging managing agents. However, that could not be approved because funding is not actually our mandate. So unfortunately, we have to assist in facilitating that kind of funding. And just to also indicate that among the initiatives that we have, it ranges from your education and training, your entrepreneur development programs, your incubation, your mentorship, as well as the scorecard, which I will talk to just in brief. And for us to, or rather, let me say, subsequent to the board approving the concept note and the minister, we then thought that it is important for us to do roundtable sessions. And so far, and also to date, we are pleased to report that we've conducted 18 consultation sessions. And these sessions were with the industry, ranging from, and Andrew, you would recall that we were unfortunately unable to meet with you because you were traveling quite a lot around that time. So we did the roundtables around April to June 2024. And from that process, we actually received quite a lot of input. And I think it's important to indicate to the members that when we received the input, we noted that the input that we received was not even different from the initiatives that we had proposed. So at this point, we now have a final report that has been drafted, and it is to be presented to the board at the end of the October. So I think last week, or rather Monday, actually, we presented the report on those recommendations to our subcommittees of the board, and they have since approved it. So it's going to go to the board at the end of October. I want to touch on the issue of the scorecard. We also collaborate with the Property Sector Charter Council, which we all are familiar with. And I think, Trafalgar, you're also a member of the council, and CSOS is also a member there too, your NAMAs and the rest of the industry entities. So we collaborated with Portia, and they have since helped us with drafting the scorecard. So we're trying to look at the scorecard, and I think we can all attest to the fact that a scorecard is a general legislated concept, wherein you will have your different elements ensuring that the procurement spend for the particular entities they will get, or the community schemes will get points as soon as the scorecard gets into legislation. Where are we with that scorecard at this point? It is in a draft format. It is going to also be approved by the board at the end of October. Once it gets approved by the board, it then goes to the Minister of Human Settlements for her to say, yes, you can proceed. And we are looking at having some few roundtable sessions to also present the scorecard. Once that is done, then there will be a process that will be followed, led by the PSCC, for that to be gazetted. And in terms of the gazette, I think we all know the process of gazetting. It takes 60 days before it gets legislated. So this is where we are in terms of the process. And I want to talk about our learnership program. Andrew, I would also, before I say anything on behalf of the CSOS, I'm going to appreciate, I think it's important for the members to know that you are really, really supporting the CSOS in terms of our learnership program. And I would like to also report to the fact that learnership, from the CSOS perspective, it is a first of its kind, so we regard it as a pilot. But I want to indicate that we currently have Trafalgar hosting 3 of our learners, who are very happy to be hosted by Trafalgar in their Gauteng-based offices. And safe to indicate that we currently have 21 cohort of learners, when initially we were looking at having 30 learners. Unfortunately, you know, these things happen. We thought of the 30, and then after we did the 30, it dropped down to 26. From 26, the number dropped down to 22. And at the time that we appointed, the appointment actually was on the 1st of August. And at the time we appointed, then one of them, I think after a week or two, then they got an opportunity. Then we are currently sitting at 21. And so it is important also to indicate that from that 21, we've got 7 that are hosted under the CSOS. We've got few that are sitting currently at the head office, and we've got 2 that are sitting at the KZN office. And I must say that this program is running very well. And I think we all can indicate that the other learners are actually hosted by our industry, and I've mentioned Trafalgar there, which we appreciate. We also have Preto who's hosting our learners, and we also have 4 of our EMAs that are currently hosting those learners as we speak to date. So it is also important to indicate that how did we come about getting our host companies? We ultimately had to sit together and agree on the terms in terms of how are they going to support us. And that actually resulted in us being able to sign 6 of our MOUs with our host companies. And I would like to also indicate, by the time that we were doing this presentation, we had not appointed our service provider. Andrew, you would recall that in August, but so to date, we have since appointed SPECON, that is our CETA accredited service provider. The facilitation of the training has actually started, which is the 30% part of the theory of the learnership program. And our first class had actually started on the 21st of October 2024. And maybe just to indicate that what will happen once we have the board approving the report based on the recommendations that we made, based on the input that we got from the industry. Once that is approved, then we'll be having a draft strategy. And once that transformation strategy is approved by the board, and we're anticipating to have it finalized by the end of November. So we are also looking at, subsequent to that, we will be having the roundtable sessions that could actually run maybe virtually. It will depend on the availability, but we are looking at ensuring that as a last round of sessions, we consult with our industry to say, industry, this is what we have put together in terms of the strategy based on your input, your recommendations. Are you supporting this? And once you say yes as an industry, then we can go ahead and implement our transformation strategy. I want to highlight a key point on the incubation program. When we had our Indaba in September, our minister actually asked for the CSOS to expand on the incubation program. Now, currently, we have 101 emerging managing agents that are sitting in the panel for the CSOS. From the 101, we only have 1 or 2 of our EMAs that are currently incubated by Mid-City. And you would recall in one of our conferences last week that we had attended, we are calling upon all our industry related, like Trafalgar, to say, can you just come in and see in terms of the number that we have, and also looking at the expertise that we currently have in terms of our EMAs. Are you interested for you to come in and incubate our EMAs? So that is actually in progress, and we have since submitted or circulated the letters to the industry. And Andrew, you did not receive the letter, and I'll tell you why. We thought that maybe let's give you a break because you're actually supporting us on the learnership. But if you are interested in incubating or informing part of the incubation program, we are very much open to allow you to come in and say you are available. You can maybe want to incubate maybe 1 or 2 of the EMAs, because we have seen that that model does really work. And lastly is to indicate that, I think I've touched on the last one actually, to indicate that the strategy will be finalized. And then as soon as it's finalized, we are looking at having at least 3 consultation sessions so that we can come to the industry and say, are you happy with the strategy, so that we can all implement? I think that's it from my side, and I'll wait for questions, and I'll hand over to my colleague, Ryan. Andrew?
Thank you, Chapiso. We're running slightly short of time, so I think I'm going to hand over directly to Ryan. Ryan, thank you. And you're going to take us through some proposed new legislation and the outlook for that. Thank you.
Not a problem. Thanks so much, Andrew. And good evening to everyone listening. I'm going to do it very, very high level, because obviously for time, and also I've read some of the questions in the chat as well. I think we should also address some of those questions as well, if possible. So in essence, what we're basically going to be dealing with here, and what the CSOS is currently busy with, is we're trying to amend our legislation in terms of the CSOS Act as well as the SDSMA, which is Sectional Title Schemes Management Act. So in terms of Section 18 of the STSMA, that a council has formed in that regard, just to provide the minister with regulations that could actually help. And these are just some of very high level. There's just some of them that has been sent to the minister, just for some gazetting. Some of them are the low hanging fruits, as we call it per se. And in that regard, I'm just going to start with the first one, which is the applicability of the CSOS Act to the Homeowners Association. In relation to this, we actually want to change the legislation currently states that in the CSOS Act that the community schemes, it refers to HOAs, share blocks, body corporates, retirement villages. There's another one that I'm missing currently, but for the interest of time, but we CSOS as CSOS we've had a situation where HOAs feel that they do not need to comply with the CSOS Act, simply because sorry, Andrew, is there like there's a noise somewhere in the background? Sorry, my apologies.
I don't hear it on my side, Ryan. I'm sorry. I think just carry on as best you can. Thank you.
Okay, not a problem. Sorry. Yes, okay. And then so yes, sorry. So the HOAs feel that they do not need to comply with the CSOS Act because they're governed by the Companies Act. But it's the same way as saying that a company doesn't need to comply with the VAT Act, for example, when paying VAT, when they actually have the relationship with the Companies Act in essence. So that's one of the gazetting that we plan to do in this regard. And then the appointment of an executive managing agent. So in terms of STSMA regulation 28.1, 2 and 2, this provision gives the chief ombudsman, there's the CISO chief ombudsman, the power to appoint an executive managing agent for a scheme when there's a total of 25% of the people that has come together to recommend same. Unfortunately, as Sis Lindy has indicated before, that CSOS is a creature of statute, and there's currently no provision that states that the CSOS can appoint an EMA on behalf of a body corporate. So in that regard, we just want to strengthen it in terms of the legality around that, and also to minimize appeals that might come as a result of the chief ombudsman appointing that executive managing agent in that regard. Just moving with haste. And then in terms of number 3, applicability of POPIA, section 3.1N of the STSMA. So in relation to this, what happens is in terms of section 3 of the STSMA, it's basically the functions of a body corporate. And in terms of section 3.1N, that's basically a reasonable request from members for the addresses and names of people that are staying in the estate. So the issue we're sitting with is that CSOS has now had a sit down, we've had a look at it, and many members have now come through and stated that it's just not a violation of POPIA. So to minimize that, we want to change the regulation to say that section 3.1N, when providing it, has to be in line with POPIA. So in that regard, the information regulator will then come into play specifically for that provision itself. And then moving to number 4, section 16, it's the appointment of administrators. So currently, in terms of the sectional title schemes and management act, section 16 is the appointment of administrators for schemes that are failing. So usually you go to court, and it's an ex parte application, and you're able to get appointed as an administrator of a scheme. However, the magistrates fail to realize that CSOS is one of the governing components of these administrators, because CSOS has to check if the scheme is actually surviving. Is the finances of the scheme actually increasing, or is it decreasing in that regard? And that's also, it's a breeding ground for hijacking of buildings in that regard. So we just need to strengthen that. There's a regulation that's going to come out that we plan to strengthen section 16 of the STSMA in order for magistrates to also be made aware that CSOS is actually the governing structure for that. Then in terms of registration of schemes, currently in its current form, it's compulsory for community schemes to pay their levies. However, it's not compulsory there's no legislation that states that it's compulsory for the registration of schemes. However, obviously, you cannot pay levies without the registration of schemes. So the one goes hand in hand in essence. So in that regard, that's just one of the issues that we are trying to sort out, and we are just trying to strengthen that in that regard. And this is one of the urgent matters that's going to be dealing with that we're going to be dealing with in the government gazette in that regard. So that's just one of the issues. And then just lastly, offences and penalties. I think there was a question on that. So the issue we were sitting with offences and penalties is that it's very difficult to enforce. For example, we, as you would know, in terms of the Criminal Procedure Act, there's different schedules for different crimes, obviously. And so this is now just trying to work out that regulation as well with the SAPS in this regard. And once we've discussed that with the minister, offences and penalties will take full effect. So we sort of want to have the same power that the information regulator has in terms of them, for example, in the recent case where they charged the DOJ with 5 million rand for breach of information. So that's the same, that's where we're heading. The same way with SARS as well, where SARS has the power to come and do asset forfeiture and all those things. So in that regard, that's just what we will be discussing with the minister in the upcoming months in order to have these low-hanging fruits gazetted before the main actual legislation is actually amended. But that's going to take a good 12 years minimum probably. So yeah, but Andrew, I think I've covered everything that I needed to cover. Thank you so much for that. Appreciate it. Sorry, Andrew, you muted.
Apologies about that. Thank you. I just wanted to ask my colleague Karine if there are any particular questions that would be worth just bringing up with our panelists, just for clarity or emphasis. But you have answered them on the Q&A, so hopefully those are answered directly to those that posed them.
Yeah, nothing from my side. Thanks, Andrew.
Okay. All right, thank you. If we could just go to the next slide, Karine. Just in closing then, just a reminder of some useful links which are worth just referring to. So, I think as you heard from Lindiwe, it's always important to exhaust internal remedies before lodging a dispute with CSOS. That makes sense. It's faster, it's more, it's more professional, it can be more direct, and it certainly can build relationships rather than break them down. It stands to reason that being informed on the legislation, on the way that common challenges should be resolved, on frequently asked questions is a good starting point, because then with knowledge, with experience, with case studies, it's possible to engage with the trustees or directors, with estate managers or building managers, with neighbors, whoever the case might be. So, please do just bear that in mind, that you do need to have a portfolio of evidence of exhausting your internal remedies, which means direct discussions, written correspondence, appearing at trustee meetings, at particular meeting discussions as well, and having documents to prove that, before you decide the dispute cannot be resolved internally and then wish to escalate to CSOS. And, that's absolutely fine, and you should do so decisively, but do so in the knowledge that you have tried, that you have your documents together, because that will also make sure you are well prepared to submit your written responses, that you have your evidence together, and it will strengthen your case in terms of the conciliation or the adjudication. As I said at the beginning, here are our contact details. You are more than welcome to contact any of us. We will endeavor to get back to you on a same-day basis. We certainly don't mind, giving free advice now or any time ahead. And, we do our best to provide support, to provide guidance, to refer you, to a particular resource. And certainly if we don't have a good answer, we work with a panelist of specialist sectional title or community scheme attorneys who can help. Don't forget to subscribe to our newsletter if you're interested in community schemes and topical community schemes issues. On closing, there'll be a short pop-up of a survey. We would appreciate you taking 20 seconds just to give some brief feedback on how you found the topic. It'll help us improve. Any other topics you'd like us to cover, that'll be helpful for planning. And then just to conclude with, thank you again for joining us. Thank you for following our training series for 2024. We look forward to resuming next year in March with similar topics of general interest. I wish you well for the end of the year and a very happy and enjoyable festive season. Thank you to our panelists, and I hope you all have a good evening. Good night, everybody.